on 1st May 2017. It was supposed to be a game changer in the business of Indian real estate. It was projected as the biggest reforms in the business of Indian real estate. Nothing seems to have changed in the last 7 years. Since its inception, RERA has continuously defeating the very purpose for which it was enacted. RERA, like very many matured countries, was supposed to bring reforms, bring transparency. Say, for example, if in Dubai, one of the globally matured real estate markets, if a developer launches a project with 20-80 scheme that you pay upfront 20% and rest 80% on possession, RERA will call up. RERA will summon the builder, ask him what is his source of funding. A developer cannot launch a project on assumptions. If you have the source of funding, put that money in the escrow account and then only you can move ahead with the project. This is how a robust RERA framework is created. In the Indian context, initially there was a proposal that the regulator will have the power to cross-check the credentials of the builder, and if he has defaulted twice in the past, he will never get a new license. That clause, that suggestion never saw the light of the day. It is hence no surprise that 7 years after RERA, we are discussing 7 unanswered questions. Question number 1, has RERA enhanced transparency in the real estate? It was supposed to bring Ram Raj in the Indian housing market. The fact is that even today, RERA is not even a platform of due diligence. It's not a platform where you can go and cross-check the credential of the developer, whether he will deliver quality product, whether he will deliver project on time. We still refer friend and family for builder's reputation. Even in terms of the online reputation, what we call online reputation management in media parlance. If 50 aggrieved buyers have written against the builder on social media or Google review, developer has the financial bandwidth to hire an agency and get 100 positive reviews. RERA is helpless in this. So, RERA has not enhanced transparency in the Indian real estate. Second question, has RERA ensured timely possession? This is one issue which was the most important factor when RERA was enacted. It started defeating the very purpose since beginning. When RERA came into existence, all the existing projects, ongoing projects were supposed to be registered with RERA. There are cases where a developer who had delayed the project for 7 to 10 years filed a fresh timeline of another 7 years and got away with it. Even today, all the new launched projects, the developers are giving as long a timeline as 6 to 8 years and privately telling the home buyers that this is just for RERA formality. We will deliver much ahead. Has RERA checked this practice? Section 7/3 of RERA talks about project timeline extension under certain circumstances. In reality, most of the projects are being given fresh timelines, even for regions, as flimsy regions as developers' financial crunch, market conditions. This simply means RERA has not ensured that a developer cannot launch a project on assumption without its financial closure in sight. Question number 3. Has RERA changed broad market practices? The market conduct, or should I say conduct of the developers, is still pre-RERA days. instances of pre-launch, IPO style launch, and all those pre-RERA practices are very much in the market. Even some developers are going on billboards saying that this is a pre-launch project. Ideally, in a RERA regime, there is no concept of pre-launch. You launch a project with all the approvals in place. Next is the contract, builder-buyer contract. It is still unfair contract, heavily loaded in favor of the builders. Despite Supreme Court's saying it time and again, there is no concept of uniform builder-buyer agreement across the country. Worse even, builder-buyer agreement is handed over to the buyer only after he has met the booking amount. So after making the payment, and there is a clause in that the developer can forfeit 10 to 20% in case of booking cancellation. Mind you, this is not 10 to 20% of the booking amount, but in most of the cases, developers define it as 10 to 20% forfeiting of the entire sales consideration. So if you have paid say 10 lakh for a 1 crore apartment, you lose your entire amount if you are not satisfied with the builder-buyer agreement. RERA mandates that any change in the project layout, the developer has to get consent of 2/3 of the buyers. In reality, nowadays developers have got so smart that they force the buyers to sign a prior consent that they can make any changes, any future changes if it is necessary. So broad market practices have not changed. Question number 4. Has RERA ensured a fair sales? After all, sales channel of the developer is the most rigged machinery. Most of the brokers on ground don't even have RERA registration. One brokerage firm having RERA registration number puts on roll 100 to 500 sub-brokers, a long chain where nobody is RERA registered, nobody is accountable. Even the house help and drivers of real estate professionals are now brokers. Secondly, RERA says that only carpet area sales is allowed. In reality, most of the developers are still selling on super built-up area. Only difference is that nowadays they put the carpet area on paper. Now the point is, if you have about a 2000 square feet apartment and the brochure says carpet area is 1200, what is the justification of additional loading of rest 800 square feet? This kind of practices can only be curbed when you are buying on carpet area as mandated by RERA law, which is not being followed. Then there is a question of arbitrary demands of the builders. Issues like asking escalation amount, asking pre-scheduled payment in construction linked payment plans. These are still the market reality. So sales channel continues to be a rigged channel even in RERA regime. Question number 5, probably the most important question. Has RERA reduced litigation burden of buyers? After all, this was one particular reason why RERA was enacted. Because we all recall that Supreme Court in its judgment on Supertech Emerald Twin Tower case had categorically said how many buyers have the might to get into costly and lengthy litigation. So RERA was supposed to reduce the litigation burden of the buyers. The reality is that RERA is another window of litigation, another additional window of litigation. RERA orders, even when RERA orders are in favor of the buyers, are just paper decree. It is not being executed. It just gets dusted in DM office or collectorate. If the buyer wants to get justice, he has to move further to appellate tribunal, then High Court, then Supreme Court. So RERA has not been buyer's recourse in legal terms. We had filed a RTI to ask whether the RERA adjudicating members, the RERA judges, have any legal training. The answer was there is no such information with us. So most of the ex-bureaucrats in RERA don't have any legal background. Question number 6. Has RERA been strict with the builders? Section 18 of RERA says, and this has been endorsed by no less than Supreme Court of India. Supreme Court had clearly said that, quoting Section 18, that the buyers have unqualified and unfettered right of refund even if delayed for 1 day. In reality, refund is mostly denied by RERA. It is denied in the name of interest of majority of the buyers. Okay, I got the point. But then in that case, is delay penalty justified? Unlike consumer courts, where if the contract says that the developer will charge 18%, buyers are also paid 18%. Here in RERA, in most of the cases, RERA gives you MCLR plus 1% as delay penalty. For those who don't understand banking terminology, MCLR stands for marginal cost of lending rate. It is the interest at which you borrow with the banks. So your refund is denied, your delay penalty is not justified. Even when the builder's agreement says that if you delay the payment, he will charge you 18%. It's a different matter that the same contract also says that if you ask for delay penalty, the builder will only give you 5 rupees per square feet, which is not even 1%. If you move to RERA, RERA gives you a compensation of MCLR plus 1%, which is not justified. Question number 7. Question number 7 is, okay, we have talked about the interest of the home buyers. Has RERA been of any help to well-intentioned builders? Has RERA been of any help to those builders who want to deliver project on time? Unfortunately, no. Because RERA cannot give orders to the government agencies who give approvals. Even when they are sitting on the files endlessly, RERA has no authority to give them any direction. So in conclusion, the failures of RERA in the last 7 years far outweigh its benefits. That is the reason why the cases of buyers dragging builders into NCLT or consumer court have not reduced in the post-RERA regime. What is the solution? Solution is to give more legal teeth to RERA, to have uniform builder-buyer agreement across the country, and RERA members should be either having some legal background or to get some legal training. Unfortunately, none of this appear to be happening in near future. We are talking about 7 years of RERA and 7 failures. Maybe by next year, we will be talking about RERA 8 years and 8 failures. I have given my honest opinion on RERA, its existence and its cost and benefit. I would solicit your opinion, your experiences with RERA. Thank you.